Hi, today we're talking about Constitutional Amendment number 6, which is the right to a fair and speedy public trial. This amendment protects a very important basic right of all people living in a democracy, and it's one that actually makes democracy possible. In other systems where trials can be held in private, where defendants can be held for any extended period of time, and when they don't have the ability to question or retain witnesses, it can be very easy for the government to hold them when they have no evidence against them or just at their own whim. So the Sixth Amendment really guarantees the success of our continued democracy and the right that we all have to know why we are being charged with a crime and to provide witnesses in our own defense. The National Constitution Center explains that this amendment actually came about because in Revolutionary era, the jury members were townspeople, people who knew both parties in each court case very well. And the thought behind the Sixth Amendment was that those jury members, who were friends and neighbors and co-workers, could look the defendant in the eye and could make a determination both of guilt and of whether or not mercy should be extended to that person. They felt that that close personal connection that the jury members had with the accused would help them to make a fair and impartial decision regarding his or her fate. Over time, of course, that concept has evolved and our current system has emerged in which you are still tried by a jury of your peers, but it is, of course, strangers in most cases. The American patriots were trying to create a system that was very different from the one that they had experienced living in Britain. In the British legal system, magistrates and judges took responsibility for the majority of court cases. They framed the questions, they questioned the witnesses, they made determinations of guilt, they really took on all the responsibility of the case. So if you got an unfair judge or one who did not like you, you really stood no chance of winning your trial. The revolutionary leaders wanted a system where defendants could choose their own counsel and hire that person to represent their best interests as the court case moved forward. Clearly, the system has worked well for our country, and again, it has evolved as our country has evolved. In a famous 1963 Supreme Court case, Gideon versus Wainwright, the defendant was not able to afford counsel. And so out of that case came the Supreme Court ruling that everyone is entitled to counsel, and if they can't afford counsel of their own, it must be provided to them. They further ruled that that counsel must be effective, and it must actually provide a good, solid legal foundation for the defendant so that he or she could make an informed decision regarding the conviction or lack thereof. If the counsel does not live up to that job, the defendant can request a new counsel. One of the most famous incidents involving the invocation of Amendment 6 was Smith versus Huey in 1969. In this case, there was a defendant in federal prison awaiting trial who was charged with a crime in Texas as well. 7 years later, the Texas court still had not attempted to prosecute him for said crime. He took his court to the Supreme Court, and the court ruled that his Sixth Amendment rights had been violated, that the state of Texas had taken too long pursuing their claim, and at that point, they had given up their right to pursue any kind of trial against him. The charges against the defendant were dropped, and the state could not pursue their complaint against him any further. Clearly, this amendment plays a big role in our everyday lives, whether we think about it or not, in ensuring that all of us have access to legal counsel if we need it, and that we all have access to fair, speedy, and public trials, not trials where the government can hide behind their personal whims and desires and pretty much do whatever they want. Thanks so much for listening. See you next time.